In this video, we're going to talk about how to pass the multi-state essay exam. And I'm going to tell you an efficient way to approach the multi-state essay exam, or MEE portion of the bar exam. I highly recommend that you download our handout, which you can find at the link, because this handout will have a lot of information in it. We'll be going through it in this video. If you don't download it, it's not to say the video will be useless. You can still follow along and take notes, but the handout is a great reference for you later, and I think you'll be very glad that you downloaded it. So I'd highly recommend that you do that before you proceed with this video. In this video, we're going to talk about an efficient way to approach the MEE. A lot of students don't realize that certain subjects are tested over and over again, and certain topics within those subjects are tested over and over again. So it makes sense when you're approaching the MEE portion of the bar exam to focus on the highly tested subjects and the highly tested topics within these subjects. That's a good way to maximize your chance of getting a decent score on the MEE and maximize your chance of passing the bar exam and never having to take it again. If you are in a uniform bar exam jurisdiction, the MEE is worth the equivalent of 105 multiple choice questions, which means it is a good part of your score and you do not want to ignore it. So with that said, let's talk about the highly tested subjects and the highly tested topics within each subject. If you look at the highly tested subjects on the MEE, you'll notice that we place them into three different tiers. Tier 1 are subjects that you frequently see come up, Tier 2 you see less frequently, and Tier 3 you don't see as much. If we look at the Tier 1 subjects, you will see that things like civil procedure come up all the time. Civil procedure is tested on almost every MEE exam. But also there's family law, corporations and LLCs, secured transactions, trust and future interest, contracts, agency, partnership, real property, and decedents' estates or wills. If you go to Tier 2, these are subjects that are not tested quite as much, but they're still pretty frequently tested. And that's constitutional law, evidence, and torts. Tier 3 are subjects that are really not tested as much, and that's criminal law, criminal procedure, we divide them into two subjects, and then conflicts of law. Conflicts of law is not even considered to be a standalone subject on the MEE, so that means if you see conflicts of law, it will be combined with another subject. If you look at our chart, you can also see when these subjects have been tested and how they've been tested. You'll see some red X's on that chart, and you might wonder what they mean. The red X's mean that these questions were offered to any jurisdiction that administered the MEE to choose from. So prior to 2014, the National Conference of Bar Examiners would write between 7 and 9 questions for the multi-state essay exam. For states that administered the uniform bar exam, the National Conference of Bar Examiners would choose themselves which 6 questions to administer. And those are all the black X's. These are all subjects that have appeared on the uniform bar exam. For states that administer the multi-state essay exam but do not administer the uniform bar exam, they could choose which subjects to put on their exam. And that's why you see there's some red X's. This means states could put it on their exam, but it was not on the uniform bar exam those years. If that's confusing to you, don't worry about it too much, because now we live in a post-2013 world, and there's only 6 questions that states can choose from, whether or not they administer the uniform bar exam or whether or not they administer just the MEE portion of the uniform bar exam. So now that we've talked about the highly tested subjects, let's talk about the highly tested topics within each subject. The first subject is civil procedure. This is tested on virtually every MEE exam. It's very popular. It was not tested on the February 2017 exam. We incorrectly predicted it because we assumed it would be coming up, but it is tested on most exams. And it tends to be tested in pretty common ways. One thing they love to test is subject matter jurisdiction, federal question, diversity, supplemental jurisdiction. You should be very well versed in these areas because they're tested in very traditional ways. If you understand the basics, you should get these right. Civil procedure questions also sometimes test personal jurisdiction. It's tested about once every 5 years. There's a trend toward testing specific jurisdiction on these questions. Lastly, civil procedure questions test transfer to a more appropriate forum. This tends to be a popular topic for some reason, and the question usually is, which law do you apply in a transfer to a more appropriate forum scenario? And they want you to know that you apply the law of the transferor court. Also doesn't hurt to know this for the MBE. If that confuses you, then go ahead and pick one of the exams where that was tested and write a practice essay, and it should make it a little bit more clear to you. Constitutional law. This is a Tier 2 subject, meaning it's not always tested, but you very well could see it. And they tend to test a few different things when they test constitutional law. Free speech is very popular. Sometimes they'll test free speech in very similar ways, so it's well worth it to do past questions. They also like to test state action. They've done this a couple times. Remember, to sue under the 1st or 14th or 15th Amendment, you need to find a state actor. And then lastly, they tend to test the Dormant Commerce Clause. This has come up recently, and I have a feeling it's going to be coming up more frequently in the years to come. Contracts and sales. This is a Tier 1 subject, meaning it could definitely come up. When they test contracts and sales, they tend to test Article 2 about half the time that they test contracts and sales. The other time they'll test common law. If it's Article 2, you should make a note that it is Article 2 and state the kind of introduction that they like to see. They also tend to test the nuances of contract formation. Offer, revocation of offer, lapse of offer, how do you get rid of an offer, acceptance, consideration, pre-existing legal duty rule. I would be well versed in all of that because they will test that and they'll test those nuances on these questions. Lastly, they sometimes test damages on contracts questions. You should be familiar with expectation damages, be able to define expectation damages, and be able to recognize them when you see them. Criminal law and procedure. This is a Tier 3 question. Usually you'll see criminal law or you'll see criminal procedure. They're usually not combined together. Recently, criminal procedure was combined with evidence, which was unusual. But these tend not to be tested as often. If it's a criminal law question, they like to test homicide. Homicide is also 3 to 4 questions on the MBE, so it's well worth it to be well versed in the different degrees of homicide, the different levels of homicide. For criminal procedure, they like to test the 4th Amendment, search and seizure. It's one of their favorites. They also love to test the 5th Amendment Miranda in terms of confessions. They have tested the 6th Amendment before and the 14th Amendment before when it comes to confessions, but the 5th Amendment is by far their favorite, so I'd be well versed in Miranda, when it attaches, how you invoke Miranda rights, how you waive them, and look back at some of those past essay questions, because if you see a criminal procedure question, it very well could be a Miranda issue. Evidence. Evidence is a Tier 2 subject, meaning that it is occasionally tested. You could definitely see it. Evidence questions tend to test either hearsay, unsurprisingly, or impeachment, or relevancy. So you should be able to find relevancy and say exactly what it is. For hearsay, they will test exceptions, they will test exclusions. You should be very well versed in hearsay because not only is it heavily tested on the MEE, it's also heavily tested on the multiple choice portion of the bar exam. It's going to make up 6 to 7 MBE questions. So if you have trouble with hearsay and the exceptions, I would do whatever you can to make sure that you clarify it, because it is going to be it could be a topic worth a lot of points on your bar exam. For impeachment, sometimes they test impeachment the exact way they've done it in the past. Like, for example, they've tested it in February 2009 and July 2014 in a very similar way. They used a prior bad act for impeachment. It was somebody lying on their resume and job application, and whether or not that extrinsic evidence could go into evidence. And it was just a very similar way that they tested it. They love to test impeachment, so I would go back and look at some of those impeachment questions, especially if you don't happen to love the topic of impeachment. Note that some things in evidence they hardly ever test, like privileges. They have tested once in February 2008. Things they've never really tested are the best evidence rule, judicial notice, authentication, expert witnesses. It just tends not to be something that they test. And of course they could test it, but so far they haven't. They've been sticking to more of these mainstream topics. And this just goes to show that if you're well versed in the highly tested subjects and the highly tested topics, that's going to serve you very well, because you're going to be well versed in the subjects that the topics that you're most likely to see coming up on the MEE. Real property. Real property can be tricky. People tend to find it to be a difficult subject and compared with others. On the MEE, they like to test deeds. They test recording acts. You should know the difference between a race notice act and a notice act. They also tend to test notice. What constitutes notice? You should be familiar with the different types of notice under the Recording Act. Lastly, they'll test leases. You should know about the rights and duties under leases and be familiar with these types of questions that have come up frequently in past real property MEE questions. Torts is the next subject. Torts is on the bottom of Tier 2, but it's definitely fair game for the MEE. Torts tends to test negligence, and this is actually trickier than some people initially think it is, so I'd make sure that you're well versed in negligence on the MEE. And look back at some of these questions, you'll see it's actually trickier than people think. It's also helpful to be well versed in negligence because negligence will be 12 to 13 questions on the multi-state bar exam. That's a good chunk of your multi-state bar exam score. So you want to be well versed in negligence for the MBE portion of the bar exam. Torts also sometimes tests intentional torts. They've tested battery, they've tested false imprisonment. I'd be well versed in how to define these intentional torts, know the elements, be able to state a battery is an act with intent to cause a harmful or offensive contact or imminent apprehension of that contact, and a harmful or offensive contact directly or indirectly results, or something to that effect, so that if you see an intentional torts question, the grader will be impressed by you. And lastly, you should be well versed in vicarious liability. You should know the difference between indemnification and contribution. This usually comes up when an employee commits a tort and the question is whether the employer is liable, and if so, if they can seek any kind of money from the employee. You should be able to say these words, vicarious liability, indemnification, contribution, and bold them and draw attention to them in your torts essay answer. Agency and partnership. On the MEE, they tend to test either agency and partnership or corporations and LLCs, but not both. So usually you'll see one or the other, but not both. However, there are exceptions to the rule, and even in February 2017, there was an agency and partnership question, and there was a separate corporations and LLCs question. So you definitely could see both, they just tend not to test both. For agency, they like to test actual authority and apparent authority. You should be able to define those. It's not on the handout, but they also like to test ratification. For partnership, they like to test formation. You should be aware of the difference between a general partnership and some limited liability forms. They also like to test creditors' rights. When can a creditor collect from a partner or partnership, and what do they collect? This is heavily tested, and surprisingly, some commercial courses do not cover it at all. So if you find that your commercial course does not cover these creditor rights issues very well, then look at these past essay questions or buy our MEE one-sheets book so that you can be well versed in this highly tested topic. Corporations and LLCs. Again, normally you'll see this or agency and partnership, but not both. But again, there's exceptions to that rule. For corporations, they tend to test the business judgment rule. You should know how to define it. You should know when directors don't follow the business judgment rule. Like, for example, they'll sometimes test it where directors will talk for 10 minutes about a big contract. They won't ask any questions and they'll just decide to enter into it. They're probably breaching the business judgment rule. And they'll ask those types of questions to see if you can define the business judgment rule and if you know how it applies in ordinary situations. For shareholders, they'll test direct versus derivative suits. You should know the difference between them. They also test piercing the corporate veil. When can somebody pierce the corporate veil to hold the owners liable? Note that this also comes up quite a bit in LLC questions. When can they pierce the veil of an LLC to hold the members liable? A lot of commercial courses don't draw attention to the fact that this comes up heavily in LLC questions, so make sure that you're aware that piercing the LLC veil is something that definitely can happen and does happen on the MEE. Conflicts of law. Conflicts of law is not heavily tested. It's a Tier 3 subject, meaning that it doesn't come up very frequently at all. It's also not a standalone subject, meaning that you're not going to see an entire question on conflicts. Instead, it's going to be combined with another subject. It tends to be combined with family law, or civil procedure, or wills, decedents' estates, or wills. So for family law, often they'll combine it with common law marriage issues, and you should know that if one state recognizes common law marriage, all the other states will too, because it's not considered to be against public policy. For civil procedure, they'll test the Claxon rule, and whether you know which choice of law dispute a federal court will apply if they're seeing diversity. And for decedents' estates, they'll often ask you to apply or state which state's law is going to apply if they're distributing real property or personal property after somebody dies. Family law. Family law tends to be trickier than people think. I've listed some of the commonly tested subjects here. They like common law marriage. You should know the 4 elements of a common law marriage. On most bar exams when they test this, they don't find that a common law marriage exists. You should also be familiar with custody, alimony, property division. These are all things that are heavily tested. Family law questions can be harder and trickier than a lot of people think. Some people think, oh, it's easy, family law, I know this, and they'll get a really hard jurisdiction issue or something else. So I look back at a lot of past family law questions. You certainly have a lot to look back at. It is a highly tested topic. You should also be aware that some courses focus on things that are just not heavily tested. Like they'll focus on artificial insemination or, something like marital rape. And that just tends not to be heavily tested on the MEE. So instead, focus on what is highly tested and, more importantly, do a bunch of past family law questions because you'll see that it's trickier than you might initially suspect. And it is a highly tested topic that is well worth it to become well versed in. Secure transactions. They like to test the basics of Article 9, attachment, perfection. You should know what a PIMSI is, a purchase money security interest. I've put some of the basic things on the handout that you should be well aware of. They want you to know that first to file or perfect has priority. That point has been tested multiple times in secured transactions questions. Another thing that I didn't put on the handout is default. They want you to know what can happen if a debtor defaults on a loan. What can a creditor do? They sometimes test on the nuances of consumer versus non-consumer transaction notifications to somebody. So I'd be well versed in this. Our MEE one-sheets are great for this if you're looking for another resource on the highly tested areas of secure transaction law. Trusts. They like to test trust validity. You should be able to say a trust is valid if it has a trustee, beneficiaries, trust property. Some courses will teach these really nuanced definitions of how to create a valid trust. Like one I wrote down was, a trust is valid if a settlor delivers legal title of trust assets, res, to a trustee for the benefit of beneficiaries with intent to create a trust for a valid purpose. But really, that's not written on the MEE anywhere. They never expect to see that. They'll just want you to say a trust is valid if it has a trustee, beneficiary, and trust property. And that's enough for them. So sometimes commercial courses make it even more complicated than it has to be, which is why it's a good reason to always look back at past questions to see what they really expect of you. Trusts questions also like to test the different types of trusts, including charitable trusts. That one tends to be pretty popular. They also test the Uniform Prudent Investor Act and duties of a trustee. Wills, or decedent's estates. Wills questions tend to focus on validity of a will. You should know that most states require certain things for a will to be valid, usually a signature, 2 witnesses, and writing. You should also be familiar with holographic will, and you should be able to say that half the states recognize a holographic will. And you should know what the dispensing power is. It comes up on some MEE questions. Sometimes in wills questions, the Slayer rule is tested. They want you to know if someone intentionally and feloniously kills somebody, then that person cannot recover under their will. However, virtually every time this has been tested on the MEE, the slayer will still get the gift, so the rule will not bar the gift to the slayer. Lastly, wills questions sometimes test intestate succession, or what to do if somebody dies intestate, like without a will. These tend not to focus on math so much, so if you hate the math portion of it, don't worry about it too much, but still be well versed in the laws of intestate succession and who usually takes under pursuant to the rules of intestate succession if somebody dies without a will. So these are some of our tips on how to pass the MEE. We have tons of MEE resources. We have an MEE seminar, we have an MEE course, we have a book of MEE one-sheets where we go through each of these MEE subjects on one page rather than just a couple of bullet points. It's actually one page front and back, so it's really 2 pages, and people love them. But we have a ton of MEE options if you're struggling with the MEE. It's such an important part of the exam. We hope that you found this video helpful. Thank you very much.